We talked about what a receivership is, and it's where the creditors realize the company may not be able to pay off their debts. Therefore, they come up with debt winding, voluntary. And they go to court and they petition the court to appoint a receiver to realize the security for the benefit of the creditor. Or this receiver will assume the management of the company. It's a rescue measure. The creditor has realized this company may not pay off my debt. So it will go to court to appoint someone to ensure that that security that was attached is realized. It's sold off to pay off his debt. If this is successful, liquidation may be avoided. If it fails, liquidation must follow. Where receivership is resorted to, it precedes liquidation. Liquidation does not come before receivership. If the company cannot be salvaged, then liquidation will follow. But the creditor must have first gone to court, must have first shown the company is not able to pay off the debts. And where a receiver is appointed and he does not manage to turn the fortunes of the company around such that the company is making good progress, then liquidation will follow. And liquidation is where that continual trend of loss, declining turnover, declining industry, obvious mismanagement and scandals. Someone is illiquid if they cannot convert the assets they have into ready cash to pay off debts, to manage the company. And these are normally, they are signs. The creditor will have seen these signs. That is why he is rushing to secure whatever asset he had used to give the company a debt. And what are the effects of appointment of a receiver? Floating charges crystallize and become fixed. Directors' powers again are seized, and the same vests with the receiver. The employment of the company's employees automatically terminated. The notice of disappointment of the receiver must be given to the company and to the creditors of this company. And the officers, the directors, the company secretary will provide the receiver the statement of affairs, the assets, the creditors, the amount due, share capital, amount not yet called, all these affairs of the company, the meetings held, the resolutions of these meetings. And the receiver can recover debts owing to the company, subject to any rights of set of which the debtor might have. So the receiver will not only be for that creditor or for the group of creditors that go. They will continue to act, especially since once they're appointed, the directors set aside. And now everything vests on this receiver. We have the duties of the receiver, and one is to take up the affairs of the company. Then demand for the submission of the statement of affairs. And once he gets this statement, he submits a copy to the registrar. He must account for any money spent. This is what we mean by periodically receipts and payments during the relevant period. We've said with the liquidator, if he sells off, again, no secret profits, no mismanagement of the funds received, no secret accounts, maintain proper books. Enable the registrar or any officer to access and visualize and question, because the assets are there and they're selling off assets to restore the creditor in the position they should have been had they not entered into any agreement with this receiver. And the receiver has the powers to borrow to enable him to carry on the business of the company or preserve the property of the company. The contract the receiver enters into will be binding on the company in as far as they are not for his own benefit and they do not put the company in a worse off position than it already was before he was appointed.